A few days/weeks ago, I did a video on the Reddit subpoena in the Bodyguard Productions matter. Here's the Bodyguard Productions matter, and then here's the Reddit subpoena that came out of it. The Reddit subpoena was denied. Well, you would think that that would be the end of it until there is some kind of news in the original case, the Bodyguard Productions case in New Jersey. Except that I received a letter, an email, from Kerry Culpepper, who is the attorneys involved in the Reddit subpoena matter. And in reading this letter, it was a curious letter. I'm going to share the letter. We're going to go over the letter in detail in like 5 seconds. But it led me down a rabbit hole, and I think you're going to enjoy exploring this with me. And I think I'll enjoy it too. So without further ado, let's look at the letter. So I get this letter. And yes, there will be multiple things to go back and look at, but we're going to go over the letter first, and then we'll go back over it. It's to my Gmail, and its subject is registered. Your video, judge denies Hollywood subpoenas for Redditors' identities in resubpoena to Reddit. From Kerry Culpepper, Wednesday, May 17th, 8:16 p.m. Registered email, TM. Certified delivery. This is a registered email, TM, message from Kerry Culpepper to me, and via first-class mail. And it says, "Hello, Mr. French, I am writing to you concerning inaccuracies in your video, judge denies Hollywood subpoenas for Redditors' identities. In this video, you repeatedly state, including my full name, that discovery started in this case on January 26, 2023, and that I served a subpoena on Reddit before discovery even started. This statement is flatly false," he says. "I have attached the reply brief that was filed. As you should know, discovery opens after the Rule 26 conference. As I have shown in the reply brief, this happened on November 7th. The New Jersey order ordering discovery I believe you are referring to is about a judge's order temporarily rejecting defendant's proposal to bifurcate discovery. She wanted the parties to go forward with document discovery so she could deal with defendant's proposal to bifurcate discovery in response to motions to compel on discovery requests. Note the order quashing the subpoena says nothing about the subpoena being served improperly. I believe you are aware of the damages this type of false statement can cause reputation in view of the tactics done by the Prenda Group. Your false statement implies that I do not follow the rules of discovery. I understand and appreciate that you have a different perspective on copyright law from me. It does not make sense to me that you would criticize copyright owners for filing a lawsuit against and ISP for failing to knowingly take actions against customers pirating copyright content, but also criticize copyright owners for suing the direct infringers in other videos. Nonetheless, I believe we can be respectful of each other's different opinions and have a vigorous debate on the appropriate boundaries of intellectual property without leveling patently false statements about other attorneys that harm their professional reputations. I respectfully request that you correct your video to point out that I did not serve the subpoena prior to opening of discovery. Otherwise, I congratulate you on the success of your YouTube channel. Regards, KSC, Kerry Culpepper." So that was in my inbox yesterday. And I replied quickly, as you kind of have to do with these baseless claims. I quoted the Reddit brief where it said, "Before discovery began between the parties." And I said, "It sounds like a genuine dispute between the parties. Reddit says you sent it early. I'd be happy to report on your letter in my next video, including your request for a correction." Great, so now I've read his letter out loud. This should be the correction, right? Now you know that Kerry Culpepper says he sent the thing timely, and Reddit says he sent it early, and there was this dispute, and ultimately, the subpoena was denied on other grounds, not denied on the grounds that it was untimely or pre-timely or moot or ripe or not ripe. It was denied for other reasons, mostly the overbroadness and disproportionality of it. Now, here's the thing, though. I equivocate a lot, and I'm pretty good at equivocating. I usually catch myself equivocating too much. Some of you who have spent time with me have criticized constructively, "Hey, Len, maybe you equivocate a little too much. Maybe when you're in a lawyer mode, you should equivocate. But like personally, you don't have to tell every story with, I think, or that might have happened, or allegedly, et cetera, et cetera, et cetera." And that case only entered discovery on January 26th, I believe. I said I believe. I said I think. I equivocated. So I'm certainly not attacking Kerry Culpepper with what the law would consider actual malice either. And I'm not sure where he thinks that would be able to prove that or actual damages. So I don't think I've defamed Kerry Culpepper. So, okay, what's going on here then? Is this just something he does? Scorpion sent me this. Tensions between filmmakers and Reddit grow in piracy dispute. March 7th by Ernesto Vandersar. Disputed discovery date. According to the filmmaker's attorney, Kerry Culpepper, discovery started when the subpoena was sent, January 7th. And any claim to the contrary is grossly negligent, untrue, outrageous, and even libelous. The lawyer reached out to Reddit asking the company to correct the record before it could be reported by the media, fearing that a failure to do so would damage his reputation. I extend Reddit the opportunity to file an amended opposition by the end of today that deletes the argument and all reference to it, explicitly notes that it was completely false, and extends an apology to plaintiff's counsel and the court for accusing plaintiff's counsel of blatantly violating the rules. Reddit wasn't convinced by this request, citing the court docket. Reddit believes there is no need to correct anything. Quote, "We do not take your accusations lightly. We have again reviewed the District of New Jersey court docket and see a January 26, 2023 docket entry instructing that discovery relevant to all claims and defenses shall commence. We therefore disagree that any portion of our brief is false and decline your invitation to revise the brief. As for your settlement offer, Reddit respectfully declines." And of course, as we know, the judge went on to deny Mr. Culpepper's subpoena on the grounds that it was basically disproportional, that it was early in the sense that, not in this dispute timeliness sense, but in the sense that if he really, really needed to unmask a Redditor as a witness against RCN, he can do that after he's tried to get the same sort of discovery completed from RCN. Let him go after RCN. Let the plaintiffs do their discovery with RCN before you start unmasking random internet users from 8 years ago. Makes sense to me. So that, my friends, though, is not the entire story. I was also taken aback by something in the screen here. Now, I know it's a little cheap to do this way, but do you see anything on the screen that stands out to you? We're going to play a little game. Give yourself a few seconds. See if you spot the issue that I'm spotting with this screen. What the hell is registered email? This is a registered email message from Kerry Culpepper. What the hell is registered email? And okay, so it's got a registered email TM in superscript there. He's got a trademark TM in superscript. Now, if you don't know about this, when you use a trademark, your trademark, you can use the little superscript TM to indicate that you're using that phrase as a trademark. And it helps you later on if you have to go after somebody for infringement or something to say, hey, look, I even notified them that I'm using a trademark. Don't use this word improperly. This is my trademark. What you can't use is the circle R unless it is registered. So I see here a phrase, registered email TM, certified delivery. This is a registered email TM message from Kerry Culpepper. I don't see registered email circle R. Although kind of funny, I do see a circle R in red to the left there of the phrase registered email, but it's not the circle R. It's just an R in a red circle. So I'm suspicious. I'm very suspicious. Dubious, even. This is starting to smack of shenaniganery. So I went to the United States Patent and Trademark Office, and I went to wherever the heck it lets me search for trademarks on this site. You go to the TESS Trademark Electronic Search System, and we're going to search for registered email as a combined word mark and the exact search phrase, submit query, boom. We get 2 marks, but they are dead. These marks are not registered trademarks. So of course we're going to explore what are these. Registered email. is a standard character mark. Applicant is Christopher Drake in Australia. The previous one, the applicant is R Post Communications. Okay. So this takes us to rpost.com, where we see something about R mail, R sign, registered, R docs, something. And it's a e-sign, e-security site, email security, e-signatures, email compliance, registeredemail.com. Registered email proof, registered encryption privacy. Notice the TMs. Notice they cannot use the circle R. They did not get a trademark. The original proof of delivery standard, the only court-accepted legal proof. That highlight is not doing any favors for me here, but now we have another trademark to look for. So now, let's figure out what legal proof is. We get 2 dead marks, but this one comes back to a live mark. Notice that they did use the circle R on legal proof. That's because they actually do have a trademark on legal proof, registered to R Post International. So it looks like to me, this company is trying, maybe succeeding at making email an acceptable proof of delivery standard. Now, I don't know a lot about this, and I'm not going to defame Kerry Culpepper's favorite email service by speaking out of turn. But this isn't a normal and accepted proof of service standard as far as I know. Maybe they are trying to get on the ground floor, make everybody feel very confident about it. It's not necessarily impossible to have email be some kind of certified proof of delivery, but as it works now, I do not think email supports any kind of certified delivery anything. I regularly have to combat spam filters in both directions, since I work with BitTorrent, and clients who are accused of legal trouble with BitTorrent and file sharing and piracy. Yeah, that a lot of that hits spam filters. So I've had to figure out how to work with all of that, and I don't see how you could serve somebody by email unless you could confirm it they had read the email. And just having an HTML callback or something, as your HTML email loads, it also loads a resource from a server that you can then tell that resource has been accessed. And you can sort of call that a read time. Like, oh, the email was read at this time because somebody's browser loaded it. Somebody's email client or browser rendered the HTML email, including this resource from a remote server that we're monitoring. That's usually how these things work. Again, I am not here to defame registered email, but I'm assuming that they're doing something similar. So it's really interesting to me that I get this demand letter based on this, in my opinion, pedantic thing. Seemingly baseless claim because, of course, as I see it, I equivocated, and I'm only reporting what Reddit wrote in their thing, and Reddit's only reporting what the court wrote on its court docket. So I'm not super worried about this one. There's a second R in the email that's not on the site. Oh, yeah. Okay, so he's talking about the circle, the white R in the red circle, and then it says registered email. Whereas when you're on the website here, it's got the white R in the red circle as the R in registered up at the top there. So they've got 2 different logos, and it's okay. And we can attack the sort of inconsistencies or whatever, but it is actually rather consistent. They've got a good color scheme here. They've got a good theme here with this these R's in circles. But this is really, this might be perfectly legitimate, but it also is on the weird side of legitimate. Like if this is legitimate, it says 190 countries since 2000. I guess they work with whatever they need to work with to get people to believe in their system. But I've been an attorney for 12 years, and I've never had anybody serve me by registered email TM. That was the first time I'd ever encountered that. So, you can understand my skepticism. You have to look into these things. Is it a scam? Is it a legitimate thing or not? And so I get this message from Kerry Culpepper that does not really need to be served like this in the traditional sense. And he's trying to make it seem like this is, very official. I don't think there's anything about this that is, so we did find that there are patents. They have patents on something. So this might be an organization that claims to own something related to certifying proof of delivery of emails and things. But from my perspective, sent up all my red flags that this was a private company doing something that private companies are allowed to do, proof of service, process servers, service of process. Those companies exist. So this could be a service of process company. But they claim they're the only court accepted, period. But then they say legal proof, which I have poorly highlighted here. Let me see if I can fix that. What did I just do? I said delete the highlight and it deleted the word. There we go. I'm a child. Sorry. There we go. It actually says legal proof. But the way this is phrased is what I'm upset about. The only court accepted, period. Legal proof. I think that suggests that there is no other proof of delivery by email, when I don't think that's true. Listen to me, Kerry. I don't think that's true. Look at all the uses of attempted trademarks or claimed trademarks. Power of proof TM, registered email TM, registered receipt TM. I think this is, okay, hear me out. Back in the 2000s, when all of the internet was really growing fast, you had sort of a run, sort of a gold rush on like domain names and, doing things that we would normally do in life, but with a computer. One click to buy on Amazon was a lawsuit over a patent, right? I think this is that. I think this is that kind of company that sort of positions itself to sort of occupy these intellectual properties. Digital seal technology, digital seal circle R, legal proof circle R, registered email TM. And then when someone comes along and uses something like that, they can say, no, we own it. We already had it. So maybe they, don't know if they have it. They say that they do, but maybe they realize that, they're not the only company that could do alternative service of process. But if they just say it loud enough and long enough, it will become widely accepted. Yeah, let's see. We can explore their website, though. It does say about our post. We're leaders in innovation, champions of service, here for you, handcrafted in California, registered encryption service adds more to our registered email service, the global standard for secure, certified, verifiable, and court-accepted email communications for 2 decades. See, I don't know of any court rule in my circles. Again, Kerry, listen, I don't know of any in my circles where the court just automatically accepts service by email. The federal CMECF system, sure, once you're registered with the federal CMECF system, it will send you an email and the judge will assume that you've been served with the documents that were posted to the CMECF system, case management, electronic case filing. That's not registered email, TM. That's not this company. That's just the government. That's just uscourts.gov. The services set up by the U.S. government, by that court. So sure, could a court, judges have freedom to adjudicate their cases fairly and process their cases as long as it's fair. Could a court choose this registered email service? Absolutely. Yes, a court could definitely do that. I'm just not aware of some widespread adoption of this by courts, and certainly not widespread adoption in court rules or something, not in the federal circuit that I practice. So Am I accusing Kerry Culpepper of untimely filing something? No. I did report on Kerry Culpepper's accused untimely filing of something and got a weird demand letter in response. Canada Post also has digital mail that is court accepted. Okay. But that's Canada Post, which sounds to me like a government organization, not a private company trying to sort of occupy the space. You know, the world is run by those who show up. This just sounds like a standard feature of many email clients these days. It's just, yeah, it just seems like it's a return receipt, like something embedded in an HTML document. Again, I'm wondering out loud how it works, not telling you that they're breaking some law or something. Kerry Culpepper. Legal proof. The registered receipt email record is a durable, self-contained, and self-authenticating record, proof record of the entire email transaction, returned to the sender for each registered email sent. Self-authenticating? So they're claiming their emails are self-authenticating. Okay, let's just see. Domestic public documents that are signed and sealed. Domestic public documents that are not signed, not sealed, but are signed and certified. Foreign public documents. Certified copies of public records. Official publications. Newspapers and periodicals. Trade inscriptions. Acknowledged documents. Commercial paper. Presumptions under a federal statute, certified domestic records, certified foreign records, certified records generated by an electronic process or system. So a record generated by an electronic process or system that produces an accurate result, as shown by a certification of a qualified person that complies with the certification requirements. Data copied from an electronic device, storage medium, if authenticated by a process of digital identification as shown by a certified or qualified person. So maybe they are considering it to be evidence that is self-authenticating under those last two items. It just sounds like a very legalese way of doing normal email things. So I'm dubious. I'm very, very dubious. Certainly there can be some room in the world for digital delivery of important documents. It's just a little weird for me to encounter a company sort of claiming it as theirs. Yes, the guy carrying piles of money. That I don't know why that's on their leadership team page, but okay. Yes, they have a lot of what looks like derivative trademarks, and they use them all. Yeah, they claim a lot of trademarks on these pages. I'm not sure how many of them are actually valid. The ones with the circle R are claimed to be actually registered. What does that have to do with Kerry Culpepper? Apparently that's Kerry Culpepper's chosen email service, and it just looked weird to me. So I felt that maybe it needed to be looked into, and yeah, it's weird. It's weird. I'm sure someone can tell me more about our post and how legitimate they are or aren't, but the way they present themselves definitely got my skepticism. So that's what I received from Kerry Culpepper. So now I'm going to search for an owner, and I'm going to search for our post. There are 30. Now, I don't know if these are all our post, but digital seal, R sign, registered email, legal proof. Oh, look, there's a dead legal proof here. R sign, certified email, registered email, dead. E sign off and side note are live. R registered email, R post is dead. The R with registered receipt with an R in parentheses is live, apparently. Let's take a look at that one real quick. Yeah, like this. Legal proof, they got that one somehow. Digital seal, R mail, alive. Return receipt, alive. Registered email, dead. Registered email, dead. Official email, dead. An R in parentheses is somehow alive. R post. A C, they tried to get a copyright symbol. The C in parentheses is dead. Digital seal, dead. Confidential with a C is dead. R post, dead. O, dead. C in parentheses, dead. But then an R post is alive. So they've been trying to get trademarks on things related to this for what seems to be some time now. I guess they're 20 years old. How the hell did they get R. Yeah, that's a good one. Let's ask. So it's an R in parentheses. It's a word mark. It's an R in parentheses. It is not a circle R. It's just an R encapsulated in parentheses, which seems a little simple to me for a trademark, but apparently they registered it all the way back in 2002, and it went through in 2004, which sounds like there was some opposition. We can find that out. So it would have gone through a prosecution history. And it has a colorful one. Let's see. 2001, assigned, approved for publication, published for opposition, abandoned. What? So they had it, and then it was quickly abandoned? I'd have to see all the details. But okay, petitioner then went through a process, I guess, to get it back into registration, and now it is registered. And then I guess they've renewed it since then. So it was actually abandoned at one point. So yeah, I don't know what to make of that, other than it just struck me as very odd to get a baseless demand letter, what I believe to be a baseless demand letter, and then have it be sent by registered email, TM, no circle R, from a company with a circle R as their logo. It's just weird. All right, well, it's been fun hanging out. I don't think I need to keep you guys any further. That's what happened. Kerry Culpepper sent a cease and desist or demand letter demanding that I issue a retraction, or I guess, or else I would suffer a defamation lawsuit for saying that he untimely filed something when it was more of a dispute over whether it was timely filed. Anyway, love you all. Thank you for your support. I have a list of you here somewhere. Thank you to Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, TechTechPotato, Gutbrodj, King Aries, The Blood-Soaked Survivors, Kyle Siefring, and don't credit or shout out this account. Let me go over to our float plane people. Thank you for coming too. And I'll see you guys later.